There it is. Okay. I hope everybody can see the screen. I'm going to go ahead and get that started. So, again, I'm David Sanker at Morgan Lewis, and dealing with intellectual property. So let's deal with, let's first of all talk about the broad scope of intellectual property. And essentially, we can categorize intellectual property into four main areas. And ones that are probably, the first two on the list are the ones that you probably are most important for the people here today, which are trademarks and copyrights. And in addition, there's trade secrets, and you're probably familiar with patents as well. And so we're gonna talk about these one at a time to talk about what is required, what sort of protection they provide, and how do you get that. So just at a very high level, the trademarks are short identifiers like a name or a logo or a slogan that are connected with a certain product or service. So, so like one that we're familiar with is like, Coca-Cola. That name is associated with the drink that you would buy with it. Copyrights are more for artistic creations, but they can take lots of different forms. It can be visual, it can be writing, it can be statuary. It can also include software programs and other things. So basically any sort of creation. And I mean, the word artistic, it doesn't necessarily have to be artistic in the sense like if you're writing a software program, it's not necessarily artistic, but it's still a unique creation. Trade secrets is a little bit interesting in that it's just anything that has value and you keep it secret. Then you can keep the protection that way. And then patents, which are inventions. So typically things that actually devices or software that does some specific function, and you want to protect that functionality. Okay, so let's look at trademarks first. So trademarks are available, and it's for unlike copyrights, which we'll talk about in a moment. Trademarks are for small things, and it's not only for the small thing, but it's connecting the word or the phrase or the logo to a specific thing or product or service, and so it's really the connection to establish that name represents a specific thing. And a couple of specific examples here was the Sprinkles cupcakes, or McDonald's slogan that they've used, "I'm loving it," or some of you are probably familiar with on the Nike shoes. You see, there's this symbol they call the swoosh. So that is very distinctive, and a lot of us would recognize that. It doesn't require words. It's just that symbol can be very effective at saying, "Oh yeah, this is a Nike product." So the important thing is it's something that's small, and it's something that uniquely correlates a symbol or words with a specific product. So down here below we say, well, what are the components of a mark? Well, it can be just words. So, for example, the quote above with the McDonald's "I'm loving it," it could be just those words, just the words themselves, or it could be a graphic alone, like the Nike shoes, or it could be a combination of those two, and sometimes that combination can be the font or other characteristic of the words. So one of the things we'll see in a moment is like the Google logo. So you could claim a trademark on just the word Google, the letters capital G-O-O-G-L-E, But you could also trademark the fact that it had in a specific font, and each of those letters is in a specific color. And so you, even for the same thing, you can choose to say, well, do I want to get a trademark that's just on the word or just on the word together with those characteristics? And that can be an important distinction because you may, and you actually might want to get both of those trademarks. So what is protectable? So not everything is something protectable. So the first question is it being used in commerce? So are you buying or selling something? So if it's just say maybe you and some friends have a word that you use or something to describe what you're doing. It's like, well, there's no commerce there. That's just, a group of people choosing to call something something, and that's not commerce. So it actually has to be something where you're buying and selling some products or services. Then the other part is how distinctive is the mark, and that's really important too, because you can't choose to use a mark that is just like somebody else's or just like an ordinary word. So if I wanted to use, a word like telephone, it's like, well, I can't create a trademark on that. That's certainly something that's well known and is being used. It's the best ones that actually we'll talk about is we're below here is we're trying to decide how distinctive is your mark. So that's important. And actually another good example of this is I was just speaking to a potential client a couple weeks ago, and they had chosen a company name that was the same as a competitor in the same field, and all they had done was added the word "the" at the front of it, so they received a cease and desist letter from the owner of this competing company, and they had contacted me about, well, what can we do? And I said, well, you're basically using their mark, and adding the word "the" doesn't change anything. So they had, and unfortunately, they had already invested a lot in using that mark, and so it's kind of unfortunate, but they can't continue using it because they were basically using somebody else's mark. And that's this third question about the key issue is like, is there a competing mark? In this case, yes, there was a competing mark, and that other competing mark had been around for 30 years, and they were basically using the same mark with just a minor change. So that didn't work. So then let's look at the level of distinctiveness, and this can be really important in terms of how much work it is to actually, if you want to get your mark registered. So at the bottom of the list is something that's very generic. So like eco-friendly, that's very generic. It's going to be hard to get a trademark on something like that. It's just describing what it is. Even above that, something that's descriptive. I have the example here, the House of Wisconsin cheese. It's like, well, it still is fairly descriptive because it's in Wisconsin and it's cheese. And so there's no word in there that's particularly descriptive. Now, in this particular example, if they used that entire logo with both the words and the colors and that image of the cheese and the image of the state, there's a reasonable chance that they could get a trademark on that because it's not just the words. But if it's just the words, they'd have a trouble getting that. Slightly more distinctive above that is global exchange. It's still suggestive of something. It still suggests that it's global. It still suggests that it's exchanging something, but it isn't clear just from the name what is being exchanged. And so it's still suggestive, but a little bit less clear what it's doing. And then at the top of the list here is something that is essentially arbitrary. So the word Google is like, well, now after we've been using this for so long, when you hear the word Google, you think of the search engine that can give you results. But prior to Google actually using that word, it had no inherent meaning at all. So it was an arbitrary choice to use this particular set of letters to represent the company and what they do. And those are the ones that are the strongest. So if you make up a term that is not used by anybody else, and it's not a real word or anything else, those are the ones that are the strongest, because you are the one who's creating the value of the mark. Okay, and let's talk about, yeah.
Sorry to interrupt. I just wanted to intervene and clarify with your example about telephone. You can certainly perhaps use the name for, let's say, something that's totally not related to telephone services or mobile phones, let's say like shoes, the same as in the case with Apple. Even though it's descriptive in one context, it's not descriptive in another context. So it's in relation to the goods or services you're offering.
Right. Thank you, Alex. And actually, along those lines of what Alex said too, it's like you could also use a descriptive or generic word in conjunction with other words. So, for example, take the word telephone, but then add on something else that other set of letters that nobody else has used, and that could also create a good trademark. So, yeah, thanks. Okay, so then the protection. So unlike the other forms of protection that you need to get some sort of you can actually start using something as a trademark immediately. And if you do that, like you could today just start using some mark as a trademark, and you can use this superscript TM, and what you're doing is you're telling the world that, hey, I'm using this as a trademark to represent my use in commerce for this mark. So there's no legal requirement on what you need to do before you start using TM. It's just you are telling the public that you're using it, and that's actually a good thing, because now the rest of the world is on notice that you are using it, and you have proof the fact that you are using this. So that's actually a very good thing to use. One step further is actually if you file to get a registered trademark, and after you get the registration, then you can use this superscript R with a circle around it, and that tells the world that you actually have a registered trademark. So in practice, what you do is use the TM initially, and then you file for a trademark, and after it is registered, then you can start using the circle R to indicate that it's registered. So we'll talk a little bit about what the process to go through for registration. So a couple of points here for the registration. It's useful to do a search beforehand, because you don't want to spend the money and start using a given mark and then have to change later. So it's useful to do a search beforehand, and you can do a search at the USPTO website using the TESS system, TESS. That's the trademark search. So that using that link, you can perform a search yourself. It's also good to do a search using Google. Do an internet search to see if a mark you're interested in is being used. And the other one I think is also useful is to look to see if the domain name is available. If you're interested in using a particular mark, well, do I have that name, say .com, is that available? And if it is, that's a pretty good indicator that nobody else is using it. because if somebody else was going to use it, they probably would have gotten the domain name. It's not a guarantee, but it's a pretty good indicator. And then after doing an appropriate search, once you want to file, and this is something that you can do yourself. This does not require a trademark attorney. I mean, you can pay money to have people do this, but it is something you can do yourself, and you can file it online, and it's cheaper to file online than it is to file in paper. And the last time I checked, the cost was $225. It's possible that it's gone up since then, but it's still relatively inexpensive. The point here, I said it's $225 per class. So every trademark is assigned to a classification that specifies the goods or services that you're interested in protecting. So it's very different if you're, say, going to protect, say, a design for shoes versus a software program versus a tool that's being used to construct nuclear facilities. I mean, all those things are very different, would fall under different classifications. And usually you file just one classification. What's the most relevant class for your mark? I had one person a few years back accidentally filed a trademark application and filed under 4 classes, and then didn't realize it, and got her credit card charged for 4 times that amount, and so it was $900 rather than $225. So keep in mind, you want to choose the one class that's the most relevant and file for that one. So once you have a trademark registration, then no one else should be able to use that mark. And the other thing about a trademark is it lasts as long as you're using it. So there's no other forms of protection have limits as to how long they last, whereas a trademark protection can last forever. So Coca-Cola can keep on using Coke as a trademark, for the next 100, 200, 500 years. I mean, there's nothing to stop them. As I presume they will continue selling, and so they can continue using that mark. So that's a useful thing. So once you've got the registered a trademark, you can use it as long as you like.
Unless I think there is only one more scenario where you can lose it, is that if it becomes synonymous with the types of goods, sort of if it becomes descriptive of the goods. And I think history knows a few trademarks, but that's only if you become very famous. And I think with Google, there was a threat of them perhaps losing their trademark if people use it synonymously with internet searching as opposed to.
Right. That's actually a really good, and one of the most well-known examples is the use of the word Xerox. So the company Xerox, created the first photocopier, but then they allowed people to be using it to try to say, yeah, I'm going to Xerox the, this, and so people were using that, and then some people still are, to mean it just means synonymous with copying. And so actually, because of that example, people realized that they've got to make sure that you don't allow your name to be used in a way that becomes generic. Today, some people use the word Google to say, oh yeah, just go Google that. And so they want to make sure that you're not using that in a generic way to just mean to do an internet search. So they want Google to mean Google and not anybody else. So yeah, good point. It's very useful to have my colleague with me to catch anything I miss. So after you file for a trademark registration, one of two things happens. One is the examiner could just say, oh yeah, everything's good, and say, oh, it's allowable. But in many cases, they'll issue an office action which will point out any specific issues that you need to deal with. And there's really two types of issues you might have to deal with. One is that there's substantive issues, and it's like, okay, yeah, your mark is too close to something else, and you're either going to have to modify it or just give up entirely. But in more often, then you also have some procedural issues that are just, it's not a big deal, but you just have to deal with it. Identify the citizenship of the applicant, or a disclaimer of generic words. So there's some other things that, like, until you see it, it's probably what are those procedural issues? But just know that there's not big deal. They're just little issues that you need to address, and they're not a problem. And of course, the question might also ask, well, how long does it take to actually get an office action? You know, because you file something and you're really excited about this, and you want the USPTO to let you know the following week. Well, that's not how long it takes. It takes longer than that. It's usually on the order of like 6 months before you hear anything at all. So after you do all the work to file it, you're just waiting around for 6 months. In the meantime, though, you continue to use the mark, you continue to do your sales, you continue to do whatever you're doing, you continue your business, but you don't expect something overnight from the USPTO. So about 6 months, and it could be iterative depending upon what the examiner identifies. So if there's a substantive issue and they say, oh, well, you're gonna have to deal with this, you might fix that, but it could come back with some other problems depending upon how you change it. My experience has been usually that either you get it allowed on the first time around, or minor fixes get it allowed. So it's usually a fairly straightforward process. So here's two links here. I think they're on the other page as well. The first of all, the link for doing the search at tmsearch.uspto.gov, and then the registration, which is at teas.uspto.gov /Ts+. And so that's where you would go to actually file a trademark application. But before you go online to file your trademark application, there's two things that I want you to think about in advance. First of all, we talked about the class on the one of the earlier slides. You want to think about that in advance to find out, well, what's the class that I'm going to use? Because during the registration process, you need to specify what class you're going to use. So figure that out in advance. So you can go to the USPTO website and look at the list of classes and figure out the one that is the most relevant to you. So get that figured out in advance. The second thing is, if you're already using the mark in commerce, then you want to have an illustration of that, and the USPTO calls that the specimen. And so a specimen would typically be a PDF or other image file that demonstrates the use of your mark in commerce. And that could be as simple as a screenshot from your website. So if you've got a website that shows your name and the products that you're selling under your name, then grab a screenshot of that. That proves that you are using it in commerce. So if you're already using it in commerce, get that specimen ready, have that PDF file on your computer so that during the registration process, you can upload that as the proof. If you're not using it in commerce yet, but are intending to use it soon, you can still file a trademark application now and say that I intend to use this. In which case you don't have to file the specimen now, but you will have to file the specimen after it is allowed. So after it's allowed, then you're gonna have to say, okay, yeah, here's my proof that I'm now using it in commerce. And so because of that, you don't want to file a trademark application too soon. If you're not close enough to actually using it in commerce, then filing a trademark application is sort of premature. And I actually had one client that I was working with through the LCCR clinic who had filed a trademark application, got it allowed, still wasn't using it in commerce, and so had to postpone when she was going to actually prove that she was using it in commerce. In order to do that, you had to pay for an extension. Actually pay more money to say, oh, I don't have the proof yet. And that lasts you for 6 months. After that 6 months is up, she still wasn't using it, so I had to pay for another extension. And that so ended up paying for multiple extensions, but still wasn't using it in commerce yet. So ended up, unfortunately, wasting money because it wasn't ready to use in commerce yet. So I really would say don't file a trademark application until you're either already using it or within 6 months of actually being fairly confident that you're going to use it in commerce, because you don't want to invest your money in something that's not that you're not using yet. Okay, so and before we go on to copyrights, if there's any other things that we should ask about trademarks, let's go ahead and do that.
Someone asked about do all trademarks need to be registered in order to be protected? And I'll do also there's a third question.
Right. Yeah, so it doesn't necessarily have to be registered, but if you ever have to enforce your rights, it's useful to have a registered trademark because having a registered trademark is effectively definitive proof that the mark is yours and that you have it. So if you're just using a TM, there's not proof that somebody else might be using it. So it's harder if you actually have to prevent somebody else from using it. It's useful to have the registered mark. But one of the things you can do is potentially just use a TM, and then at some point, if you see somebody else using a mark, at that point I would say definitely register it. So it's sort of a gray area, and I would just say it's useful to have the registered mark at some point in time. At an early stage, if you're just very early stage, it's like, well, people are probably not going to copy your mark, in which case that gives you time. So it's like, maybe use the mark for a year or two and then file for a trademark later. And then you can tell the USPTO that, hey, I've been using this, and here's my proof that I started using this mark 2 years ago. And that's actually beneficial to you're establishing the value of the mark by your usage. So the main thing is if you've got to enforce your rights and tell somebody else to stop using this because this is mine, it's useful to have your mark registered at that time.
Thank you, David. There's also one more question. I'm going to go ahead and unmute the participant, Madeline, so that they can ask their question.
Great.
Hello, hi, Madeline here of Glam Jam, and I was curious about the photo. If the photo or screenshot needed to be of me physically selling my product, or just the fact that it's on a commerce site.
Oh, right. Yeah, it doesn't need. I mean, the only two things that are essential is that the proof needs to show the mark, whatever the mark is. And if the mark is a logo or the mark is a word, whatever the logo is, and show the connection with the product or service. So like if your logo is for selling T-shirts or something, then having a website that shows the T-shirt and has the name on the same web page is good. Or you could have a photograph of the shirt together with a tag on it that's showing the logo. So as long as you have the name to be trademarked and an item or service in the showing the conjunction of those two together, then you're good.
Okay, excellent. Thank you.
Great. Yeah, I did have one example of a client that had a website and that what she had submitted the first time wasn't clear enough that the name, because I think it was on, there are multiple web pages, and like some of the web pages showed the name, and some of the web pages showed what the service was, but what was submitted didn't show the conjunction of the two, and so the trademark office said that's not good enough, and so so I said, okay, well let's just get a little bit more here to show the context, and by resubmitting it, that worked. So if for any reason what you submit doesn't work, it's not like they're going to say okay, you lose. They're going to say okay, try again, and give you another option to do that.
There are a couple more
Okay.
questions.
Okay,
Is
fine.
that okay, David? One, the question is, I am into graphic design. How do I protect my online designs for sale? If I draw an image of a famous person that has died, is it my intellectual property, or am I infringing on their rights? And there's one more
Okay.
question after that.
Okay,
So
so let me
you
think.
can go ahead and answer that one.
That's a copyright question, which is our next one. So that wouldn't be trademark, that'd be copyright.
Got it.
So maybe we'll talk about that when we talk about copyrights.
Okay, perfect. And then the other question is, can I register my logo, business name, and slogan all for $225 at the same time?
Oh yeah, if they're distinct, then each one of those is a separate mark, and each one's going to cost $225. So what I typically recommend is like if $675 is too expensive right now, then just start off by choosing one, and then get that one allowed, and then once you got that, then that's giving you more time, and then proceed with the others. So yeah, so those are distinct marks, and so they would need to be filed separately, but there's no requirement that they all be filed at the same time. So for people with an unlimited cash flow, you just file. It's like, oh yeah, just file them all. But if that's not the case, then just choose the one you think is which one's the most important. And in the case of like if you have if you have a word, and that word is the part that's the most important, then file that one first. But also the logo could be pretty good too. So maybe to start with the logo, you leave the logo or the word.
That was it in terms of questions.
Okay, and we'll make sure we get to the question about copyrights at the end of that.
Okay, great.
Okay, so copyrights. So a copyright is for any original work of authorship, and I think we got some pretty good examples here. Books, movies, art, music, marketing materials, a website, or software code. And I was like, I've also worked with clients who have who was developing statuary. In fact, yes, statuary certainly is an example of original work of art. So it's like, and it doesn't necessarily have to be artistic, but it's just like, well, is it unique, and is it original work? So it's pretty broad, but the second bullet point here is important, that it does have to be in a fixed medium. So in general, it's like, okay, is it on paper? Is it the sound? Is it recorded? Do you have it on a website? So it's got to be in some fixed medium. And you might wonder, it's like, well, how could something be not in a fixed medium? And an example of that would be like, so this presentation today is being recorded. So a fixed copy of it is being created. But let's suppose this wasn't being recorded, and it's just my voice, traveling across the internet. That's not fixed in a tangible medium, so that's not copyrightable. The fact is that because it's being recorded, there is a copyright being created as we go for this presentation. So that's the point. It's got to be tangible. Usually things are in a fixed medium, but sounds are sometimes where that can be an issue. So then let's look at some areas where it's not available. So like names or short titles. It's like, well, that's not something that's really suitable for copyright protection, or short phrases or facts. It's like, well, if it's just a fact, it's like, well, then it's not something that you really created, because it's just a fact. There's a really well-known example of that is like, what about a telephone book? Somebody spends a lot of time to compile this telephone book. Of course, nowadays, not too many people use a physical telephone book, but they used to be pretty important. The fact is, it's like, well, there's nothing creative about that, and there's a court case that said, yep, this is not creative. You can't get a copyright on that. So just the fact that you have alphabetized it by names or something does not create a copyright. Also, recipes or ideas or other things. So it's basically, if there's nothing that's sort of creative about the work, then you can't get a copyright on it. And that sort of goes along with the idea that short phrases aren't good enough either, because it's like, well, how much creativity can you put into a couple of words? So there has to be enough in order to make it significant. If it's a set of words. On the other hand, something that is more of a art in the sense of graphic art, sometimes even something relatively small could be copyrighted. Like if while you're watching this presentation you are creating a doodle, you've got a copyright on your doodle. Not that anybody necessarily wants it, but it's your creativity that is creating it. So there's a little, even if it's relatively small, there's more leeway there than a combination of words.
Just to interject here, so for, let's say, if you take the examples for recipes, I think you can still get a copyright in the collection of the variety of recipes in a book with recipes. So the organization or the collection of them could be also creative. So you can definitely, even though you cannot get copyright in the individual recipes, you can copyright perhaps the collection.
Right. Yeah, actually, there was also along those lines too. There was a court case about someone had created a methodology for tracking general ledger. If any of you are familiar with that, money. It's like, and so they created some forms for doing that, and they thought, oh, this is kind of artistic. Well, the fact was that the court ruled, it's like, well, rather than being artistic, it was functional. And it was the functionality that was important, not being artistic, and so they weren't able to get a copyright on that. So again, the focus here is on the artistic quality, and not the something that is functional. And that's one of the things about a recipe. A recipe is it's a functional thing about how to create something. Okay, that's fine. So then let's look about what rights do you get under copyright protection. So there's multiple here, and that's useful to keep track of all of these things. So you have you can protect the display of your copyrighted work. So if you've got it, you say, okay, nobody else can display this. They also can't reproduce it. So like, let's suppose you created, a wonderful piece of art, and somebody says, oh, I'll just take a photograph of this and display it on this. Like, so they've reproduced what you've done. So it's like that, they can't do that either. Or they can't even say, like, let's suppose you've created work, and then they say, oh, well, I didn't take a photograph. I actually, painted this, but it's, it's a copy of that. It's like, that still doesn't work. That's still would count as a reproduction. And they can't also distribute or sell copies of the copyrighted work. Now, of course, there's also a doctrine about that. You can kind of imagine, well, let's suppose that you buy something that is copyrighted. It has like either a piece of artwork, or even let's suppose you have a T-shirt that has some unique art on it, and you buy it. Can you then resell it to others? And the answer is yes. Yeah, it's like there's a doctrine specifically saying that you, I mean, if you are a legitimate owner of something, then you can then sell it to someone else. You're not creating new copies of it to sell to others. So but you can sell the things that you have bought. And then there's also, this gets a little more interesting. It's like, well, what about derivative works that are based on the original? So this is an interesting one. So like, well, like there's the works that involve Sherlock Holmes, and with all of the information about the sort of that on that particular platform. You've got the characters, you've got the geography, and everything else. And so you couldn't create your own Sherlock Holmes novel, because it's like that would be a derivative work. What's the interesting thing, I was just talking to someone the other day who said that I think the Sherlock Holmes is just now out of copyright, so I think you actually can do it now because the copyright has expired. And then there's also the right of publicity, which is to perform audiovisual work. So you can't then use something and perform it. So like radio stations, they have an arrangement with the copyright owners in order to be able to play the music. They can't just say, oh, well, I'm going to play whatever I feel like. They have to, in order to do that, they have to get permission, usually by paying royalties to the copyright owners. Okay, so now this is something that is similar to what we talked about with trademarks, in that you get some immediate protection just by the fact that you create something. So like my example, if you're creating a doodle, it's like, well, you automatically got a copyright on that. You don't have to do anything. It just exists. And you can also, unlike the circle R for trademarks, you can use the circle C even when it's not registered. And that says yes, and because it's just telling the world that I'm using this, I have copyrighted this, and it's just letting people know that you intend it to be copyrighted. So you can use that for copyrights. But the question is, and we're gonna talk about this. It's like, well, what sort of protection do you have? And so just let's look at the registration process. First of all, copyright registration is inexpensive. You can do it, file it online at copyright.gov, and I believe the current price is $35. And so it's a very small price to pay, and it gives you pretty good protection. And there's an important difference between common law protection and the registration, in that it's easier to go to court in order to actually enforce your rights. If you actually haven't got a copyright registration, it's going to be much, much harder in court to actually prove that you were that somebody was infringing your mark and that you're entitled to damages. If you've gotten the registration, then it's much easier to say, yeah, I've got the registration, and you can prove that to the court fairly easily, and the person was copying it, therefore the court can just say, yep, we'll award you these fees, and potentially even get attorney's fees. So because of the fact that copyright registration is easy and inexpensive and valuable, it's definitely something that I recommend doing. And let me say something. Sorry, my brain's got off track for just a moment. Yeah, the question is, well, do I have to pay for a separate registration for each piece of artwork? So I've had this example before with somebody who was creating artwork that they were going to put on T-shirts, and they had lots of designs. It's like, well, do I have to pay $35 for every single one? And I believe the current rule is that you can file up to 10 separate items with one registration. So you could create, 10 designs, put those all together in a stack, and file that as one copyright registration. The other thing is that unlike trademarks, and we'll later talk about patents, copyright protection, there's no examination. It's just you file it and you got it. So there's no examination. It's you're just once you've filed it, you've got the protection. So now, of course, it can get a little more complicated if you have employees or independent contractors. So if you have employees and you've got an employment agreement, then typically the work of your employees is yours. You've got the copyrights for that. And if you've got independent contractors, then you want to have an agreement in place that specifies that the work they're creating is a work for hire that you own. So if you are paying an independent contractor to create something for you, you want to have in the agreement that this is a work for hire and that you own the copyrights. Make sure you got that in place. It doesn't have to be very complicated. Just make sure that it's designated as a work for hire and that you own it. Copyrights are valid for a very long time. Life of the creator plus 70 years. So they'll be valid, long after we're gone. So realistically, they're almost valid forever. Not quite, but a very, very long time. Now, enforcement can be a little tricky because there are things that limit what you can protect. And a very big one, I mean, there's multiple exceptions, but one of the biggest ones is what's called fair use. And it basically says there's a limited amount of things that other people can do, and it sort of says, yeah, this is fair use, and that's not considered infringement. And so there's 4 factors that the courts would look at to say, well, is this fair use or not? And so the first one is like, what's the nature of the use? So for example, let's suppose that in your house you photocopy something and you post it on your wall and you look at it. Well, that's not really, you're not really decreasing the value to the copyright owner. So that would be fair use. So it's like, well, how big is your use, and how much is it affecting the copyright owner? And then the nature of the copyright work. So again, is it something like, are you copying something that is a substantial work of substantial value to somebody, or is it much smaller scale? And the other part is like, well, how much of the work have you copied? So, for example, at lots of universities, you have professors creating readers that have portions of books or other articles included in the reader, and generally that's considered to be fair use. As long as they're not, you say, copying an entire book and just saying, oh, well, I've made these copies. Well, that would not be fair use. But if you, say, copy a couple of pages out of one chapter, that's not so significant. And then this last part is like, what's the effect of the use on the value of the copyright work? So in other words, how much are you decreasing the value of the copyright work to the copyright owner? Are you decreasing the amount of income that they can make based on the copyright? And if it's not really having any effect on them, then it's probably fair use. But if you're decreasing the amount of money that the copyright owner should get, then that's probably not fair use. So fair use is kind of a sometimes it's unclear. Like I said, there's just the 4 factors, and it might be unclear, well, how do those factors play out? So if you are copying something from somebody else, then it's useful to get an opinion from a counsel or something to get an idea, well, would that be considered fair use or not? Sometimes I don't think the answers are entirely obvious. So you might want to get that, get some opinion. So let's suppose that you have a copyright and you want to enforce your rights. It's like somebody else is using it. It's like, so you can, ultimately the thing you could do is litigation. You know, take it to court and say, hey court, have this and tell this person to stop. But going to court is expensive. It is expensive money, time, and energy. So before you do that, you try to take care of this the faster way, which is to send a cease and desist letter. So a cease and desist letter is usually you can't send that by yourself. But I mean, if you've got somebody who's doing this and you're not, you want to make it clear, it may be worth hiring an attorney just to prepare and send the cease and desist letter to demonstrate that you're serious about that you want them to quit using your copyright. So a cease and desist letter is the first step, and only if that doesn't work, then you have to file a lawsuit in court. And if you're doing that, of course, then you pretty much would have to have an attorney involved. And that process can be expensive too. So you probably don't go there unless there's, the value is enough. So it can be, depending upon the nature of it, it can be, there are a limited amount that can be done through a small claims court, but if the infringement is substantial, it's going to be more expensive than that, requiring a regular court. Okay, and so here's a couple of links to for copyrights. So so just www.copyright.gov. That's the website, and you can file multiple registrations together. And if it's $35, it's only $35 if it's only one work by one author. So we saw before that common law protection is automatic, and you can use the C symbol even when it's not registered, and you can register up to 10 distinct works in one filing. So the process is relatively cheap and relatively easy to do. And one thing, in addition to works of art, like if you have a software that you have created that maybe you're providing that software or something, you can also create get a copy of that software, and you can file that. And actually, you don't even have to file all of the software. You can just file a subset of the pages. So if it was like 100 pages of software code, you just typically file like say the first 10 pages and the last 10 pages, put that together, and you can file for a copyright on it. So the process is pretty straightforward. It's worth doing. And what I recommend is if you're creating artistic works regularly, then it's worthwhile looking at what you're creating, say every 3 to 6 months, and say, oh yeah, here's the new works that I've created now, and do a new filing, every 3 to 6 months for the new work that you've just created. So let's open it to any questions about copyrights.
David, there's one question still about if they draw an image of a famous person that has died, is it their intellectual property, or are you infringing on their rights?
Right. So in that particular case, you're probably safe because it's like the art is created by you. So it's your artistic work, and so you would own the copyright on the art that you have created. the other intellectual property rights, there's which actually I think may only apply to people who are alive, but they've got the rights of publicity, and that's why. So your question about someone who's died is actually an important point, because like if you just take a photograph or something. It's just a little bit more nebulous, but if you're creating your own artwork for somebody who has died, then yeah, you're pretty safe. And I think Alex is probably looks like she wants to add something there.
Yeah, I was just looking. I think there is some post-mortem rights of publicity. So technically, even if they died, they might have some rights associated with their likeness that is inherited by their relatives. So it's probably state specific as well. So
Yeah.
right.
Yeah. So yeah. So it's like in a sense, it's like the issue is not violating somebody's copyright. It's that would be a right of publicity, and that's a little bit more nebulous. Like Alex said, it's based upon individual states. So some states have stronger protection on rights of publicity versus others. And I think maybe what we could do is we could look at that question and get a more definitive answer, and do a follow-up after this talk. We can make sure that we've got that, and we'll make sure we've got the answer and get that to Anna so that it's available, that can be distributed to you. So that's again, our discussion today is not, we're not focused on the rights of publicity, and so I want to make sure we don't say something that's incorrect about that. So we'll find out more about that one. But in terms of the artwork, if you create it, you have a copyright to that. You certainly, it's like, because that's your own work. Is there any other part to that question that we need to answer?
That was it on that question. It looks like there are no other questions lined up.
Okay. Okay, great. Well, let's talk about. Okay. Oh, sorry. I forgot that. So this avoiding copyright infringement. So we might be tempted to, when we see things online, to say, oh, well, I can just copy that. You know, it's easy just to pull things down to use those. Be careful about that, because lots of things you see online have copyrights, and so just because you physically can copy something doesn't mean you're legally permitted to do so. And particularly if you are using something in a business context, I would say just be very careful on that. And so the second bullet point here is, it's like, you know, consider using things that are available on Creative Commons, because on Creative Commons, people have specifically put things there that said, yes, you may use these. So then there's no question about whether you've got copyright infringement. And then there's sometimes you can get also stock images for low-cost artwork. So just be careful about using other work. Particularly, it's like there's a big difference between whether you're using it for business versus if you're just using something for yourself. You know, if you're just using something for yourself, it's like it's going to be unlikely that any sort of enforcement can happen. But if you're using it for a business, it's more likely. Okay, trade secrets. So trade secrets is quite interesting, because unlike everything else where you can, you know, sort of have a registration, trade secrets, the value is created by keeping it secret. And so that's something that you do entirely by yourself. It's not like somebody else is doing the work for you through some sort of registration. There isn't a registration process. It's valuable because it's valuable to you, and you keep it secret. And by doing that, that's how you maintain the value. And so trade secrets you can have for anything that has business value. So it's just any sort of confidential information. Can be technical information, it can be economic, it can be engineering information, it can be, so for example, the same thing that you could file a patent application for, it's an invention, yeah, you could keep that as a trade secret too. You could theoretically, say, I mean, anything that has value, you can keep as a trade secret. One of the ones that's most famous is because the exact example I said, the product formula. So Coca-Cola has their secret formula for how they create this. That's supposedly in a safe someplace that nobody, very few people can see. And so you're keeping it as a trade secret for that. Of course, there's, as we'll talk a little bit later, it's not quite as secret as you might think, because once something is being sold as a product in the marketplace, anybody could, subject it to chemical analysis to figure out exactly what's in it. And so it's not quite as, it's more of a, it's not really as secret as they want you to believe. But anything that you keep as a secret, you can, as long as it has value, you can keep it as a secret. And so it's got to have economic value. It's got to be not known to others. And this last part is important. You've got to take reasonable measures to keep it secret. So a lot of times people say, oh, well, of course it's secret. I've just marked it confidential. And it's like, well, that's not necessarily good enough. It's like, well, what else are you doing? Because if, let's suppose you got, like a company has 500 employees, and it's like, and there's a database that everybody in the firm can access, and that database has this information that's supposedly secret. Well, that's not very good protection. If everybody in the company can get that information, that's not very secret. So to keep something secret, it requires both physical means to keep it secret. That's like keeping things locked up in a safe or behind closed doors, or whatever, as well as electronic means. So have you limited access to this information electronically to say, so like only certain people can access this information? Having it labeled confidential is good, and making sure that it's limited to the who can see it. And then we're also going to talk about non-disclosure agreements. So like, let's suppose you've got a product that is really unique, but you have to have a manufacturer construct it for you. It's like, I don't have the facilities to make this thing, so I need to tell somebody else about it. Well, you make sure you have a non-disclosure agreement with that party. Say, okay, we're going to disclose this thing so you can build it for us, but you can't tell anybody else about it. So you have non-disclosure agreements in place. So these are the sort of things that you need to do to make sure that it's kept secret. And the way to look at that, one time somebody described that to me, is to say, think about it, it's like if you have to go to court. And if you have to go to court, you're gonna ask a court to say, hey, please find this person has stolen my trade secret and tell them that they owe me a bunch of money. And so the court's gonna ask, it's like, well, how well did you protect your secret? If this was really secret, how well did you protect it? And if you didn't spend the time to keep it secret, the court says, well, if you didn't spend the time to keep it secret, why should I enforce it? And so think about it in that way. It's like, keep it as protected as well as you would want it to be, if you want to be able to persuade a judge that, yeah, I really did keep this secret. And so therefore, if it was stolen, that the court is willing to enforce it. So of course, anything that's public, that can't be kept as a trade secret because it's like it's already known. Okay, no registration process. They're protected by the company itself, and of course, because it's kept as the protection is by just keeping it secret, is that trade secrets can last forever. So there's no limit to how long a trade secret can be kept. So that can be really valuable. Oh wow, if I can keep this secret for a long time, that might be really worthwhile. Okay, so let's talk about a few strategies. It's like, so first of all, you have to keep it secret. Use non-disclosure agreements if you have to disclose it to anybody. Don't reveal it to anybody. If you think something's untrustworthy, don't disclose it to them, even if there's a non-disclosure agreement. If you have any reason to distrust someone, then don't assume that a non-disclosure agreement is going to prevent them from letting it out. Of course, you have all employees should have non-disclosure agreements, and where permitted, you also want to have employees sign non-compete agreements, which says they can't compete using that information. A lot of places, in particular California, do not allow non-compete agreements at all. And in fact, the Federal Trade Commission just said that they're considering preventing all non-compete agreements. So they may go away entirely. So this one's probably not that important anymore, because it seems like it's just most people are not being permitted to use this. And in particular, if your business is just in California, you can't use it. But non-disclosure agreements, yeah, that you want to have in place. Okay. So trade secrets, they can be very useful. So you can probably guess, well, if I've kept this secret, how could anybody get this? And the answer is that the most common way that this occurs is by having an employee who then leaves your company and then says, oh, well, I'll just use this information and I'm just going to use it for myself. And so that's the most common case. And so when you see trade secret litigation, it's usually from former employees who have taken information with them and they're using it. And so we know that we can know whether they had access to it, and if they're using that information, we can go to court to say, yeah, we kept this secret, and we had this person sign a non-disclosure agreement, but they went to work for another company, and they're using this, and in which case you can go to court. On the converse side of this, if you have higher employees who are working for you, you want to make sure that they are not using any trade secrets that they took from a former employer, because you don't want to get sued from somebody else to say, hey, you're now using my secret, I'm going to sue you for a lot of money. So anytime you are hiring employees, you want them to actually, not only do you want them to sign a non-disclosure agreement, you want them to sign something that says that they are not using any secrets that they have taken from anybody else, because you want to be protected. You don't want to end up having those employees use secrets from somebody else. I think Alex has something to add to that.
Yeah, just to add a little spice here, you can also carry a criminal liability if you steal somebody's trade secrets. So you can go to prison.
Yes, we don't want you to do that. Anyway, so it's like it's good monetarily. It's good from the legal standpoint, and you don't want to get criminally prosecuted either. Okay, and so I'm just looking at the time here. So I might have to go through the patent portion a little faster because I only had like 15 minutes left to stick with an hour and a half. Patents are very useful, and so it's basically available for inventions of any sort, that as long as it's useful and new, and you got to tell the patent office how you're creating it. And I think my note here at the bottom is I think kind of the overall thing, which is like patent law is complex. And if you think you want to file a patent, you really need to consult a patent attorney. What I've described up to now in terms of trademarks, copyrights, and trade secrets is all something you can pretty much do yourself. Just like with a little bit of guidance, you can do it. Patent law, you don't want to try to do that yourself. It requires an attorney to help you with this. And it can be expensive, and I don't want to underestimate the cost of it. It can be expensive, and so you really have to decide, well, how valuable it is to you. And let's just spend a little bit of time on that. So if you get a patent, you can prevent other people for 20 years. Of course, and the second part here is like if you file for a patent application, patent applications become public, so there's no longer trade secret protection. So usually you say, okay, sometimes you have to think between, okay, can I keep this as a trade secret, or do I want to file a patent? So there's sometimes that dichotomy, and that's, I even give a whole presentations on just that question about whether to keep something as a trade secret or to file it for patent protection. So it's a non-trivial issue, but if you've got inventions, contact a patent attorney about that. So let's look at the costs, both in time and money. For money, it's like, well, preparing a patent application, there's a lot of attorney time that's going to take. And then you've also got the patent office fees. And then even after you've got it filed, it's not like the patent office just gives a yes or no. There's an ongoing negotiation process that can take a year or two or more. And so that process can be expensive. And of course, that additional time can mean additional patent office fees. And then even once it's allowed, then you got to pay an issue fee. And then the patent office really socks it to you. It's like, if it's valuable to you, then they also charge you maintenance fees. So every 4 years after it issues, they say, well, how valuable is this to you? If it's valuable enough to you, then you got to pay us more money. So there's a lot of fees between attorney's fees and patent office fees. So it's an expensive process and a time. It's typically, figure about 3 months to prepare a good application. Once you've prepared it, figure you're going to wait at least a year. And average is more like 18 months before you hear anything, which can be very annoying. It's like, you worked really hard to do all this work to prepare a fantastic patent application, and then it's like, well, why are they doing something on it? And the fact is that the U.S. Patent Office gets about 500,000 patent applications a year, and they have a bunch of patent examiners, but not enough. And so that's the backlog. It's actually, the backlog has been worse. It's doing better than it was. So then after you wait, then you got this ongoing negotiation. Figure that can last a year or more as well. So it takes a bit of money and takes a bit of time. So it's something you have to be really convinced that this is very valuable before it's worth filing a patent on. One thing is good, if you're a micro entity, which basically means like if you're a very small company, like with just a couple of employees, and you're not making a bunch of money yet, you get a reduced rate that the patent office charges. So it's about 1/4 what the patent office charges. Of course, so here's the criteria. I mean, if you're small, there's a good chance you'll qualify. So a micro entity, so a large entity pays full price, small entity about half price. If you're a micro entity, about 1/4 the price. However, and this is the big issue, is that the biggest costs are actually paying a patent attorney to prepare the application for you. So those fees, the fact that the patent office is charging a bit less is nice, but it doesn't reduce the amount significantly because the biggest cost is for the patent attorneys. That's a big cost. So cost, time, money, eventually become public. The benefit is that if you get the patent, then you've got very strong protection. Unlike copyrights, a patent is very strong protection. You can say, yeah, this will, you can say, if anybody's doing this, it's like, here, I've got this patent on this. And the most valuable part of it is if you are going to be looking for investors or buyers for your company, then it's useful to have patents in place just to say, hey, yes, I've got some protection. So the alternatives, it's like, well, a provisional patent application we may have heard of, it's sort of, all that does is buys you some time, because a provisional application does not actually provide protection. It's just saying you got to file a provisional application, has a lot of information about what you're doing, but you actually haven't filed a real patent application yet. So it's just buying you a year's worth of time. And but maybe in a year you can say, oh yeah, well, this really is valuable or is not. So you may be able to file something inexpensively as a provisional application, and then gives you a year to figure it out. So that may be a good idea, or you may just say keep something as a trade secret. So yeah, document process. I don't know. Yeah, I'm not worried about it. That's not that important. Yeah, this is the important thing. It was like, what about patent litigation? Well, it's like, if you're a small company, patent litigation is too expensive. It's like it's just the price tag is way too high. So why get a patent at all? I mean, and that's a legitimate question. So if you're only going to do something by yourself, and you're not actually going to be licensing it or selling your company to somebody else, then it's really questionable. Like a patent is probably not that valuable to you, because it would be too expensive for you to actually enforce your rights yourself. So a couple of patent links. So the patent office, you can use that because there's some searching, or just as you may have seen Google Patents. So in addition to the standard Google searches, they also have Google Patents, so you can do searches there, which can be very helpful too. So if you have an invention, particularly if you know the right words to describe your invention, that can be helpful for seeing if the invention has already been created. So, and then so you already know about the Lawyers Committee for Civil Rights, and they have the workshops like this, as well as they have clinics. My data is old here about when the next clinic is. Actually, there's the next clinic that I'm actually, Alex and I are participating in, is in 2 days, just 2 days from now. We're at the clinic, and the clinic is a one-on-one where we spend an hour with an individual client, and we can talk specifically about whatever your specific need is. So rather than a general presentation like the present one, it's like, okay, what is your specific need, whether it's trademarks, copyrights, trade secrets, or patents. We can address whatever your needs are within the clinics. So I think those are very good. And so clinics is there's an hour to meet. And then if you need more time than that, then it's like more than a single hour, then LCCR can actually see if you can get attorney matching to get an individual attorney to spend even more time with you for a longer project. So with that, I think that's it. If you have any questions about any of the topics that we talked about today, happy to answer those now. And if any of you need some more specific follow-up, we also have a chance to come to the clinic. And if you make it to the clinic in 2 days, the clinics typically are every month or two, and Anna might be able to say more about that.
Thank you, David. Amazing. And Alex, thank you so much for your presentation. I think you answered a lot of questions. We will be sending this recording and the presentation slides by email. Just quickly, there was a couple questions on copyright rules book user that I wanted to just share, that we will again be having a Thursday. I think we're actually all this on February 9th. And I sent via chat for folks to register through the email record. Everything will be sent out as but yeah, there was a question about copyrights for children's books and there being any different rules for copyright.
Oh, I am not aware of any differences for children's books. So it's a work of original work of authorship. So you can get copyrights for that just like any other work. So yeah, there's no reason that would be any different. It is an original work of authorship, so it satisfies all the same follows the same policy rules as any other copyrights. In fact, I created a children's book myself last year, so I'm testing it out.
You'll have to share the title in the chat, David.
Oh, okay.
Yeah. Well, thank you so much, everyone. And again, thank you so much, David and Alex. We really appreciate your support for our program, and feel free to connect with us on our website. We have all of our events coming up, all our clinics, as well as upcoming workshops. So feel free to join those if you can, and if you want to. But thank you so much.
Great. Thank you all.
Thank you.